everyone. Hope you're well. So to dive right in, guys, the topic that we're going to cover today is the cancellation of a sale agreement, and a confession was that I was going to do the cancellation of an agreement and occupation, but once I started drawing the slides for the cancellation, I realized it was a slightly bigger topic than I thought it was. So what I'll do is I'll do occupation, issues around occupation, and next time we have this webinar, which I'm actually vaguely hoping will be in person, actually. But I suppose we'll see what the powers that be say. So what I want to try and do is I want to try and cover, broadly speaking, the issues around cancellation of an agreement, and see if I can, just give everyone some ideas. So, guys, there's a lot of ways in which an agreement can be cancelled or terminated, and what I'd like to do is just try and explore some of those issues and those ways, and just try and give you some ideas around those. To speak more broadly, though, I think to start off with, and I just want to talk a little bit about suspensive conditions and ordinary conditions. So a suspensive condition is a condition that suspends the operation of the contract entirely until that condition is then met. And an ordinary obligation is an ordinary obligation. So, so for example, this agreement is subject to the purchaser being granted a mortgage bond within 30 days for R1 million. That's a suspensive condition. Agreement is suspended until such time as that condition is 100% fulfilled. An ordinary condition, for example, the buyer has the obligation to pay a deposit in the sum of 100,000 Rand within 5 days of acceptance of this agreement. That's an ordinary obligation, and it's important not to confuse the two. So with an ordinary obligation, the agreement, if the buyer doesn't pay the deposit within 5 days, the agreement doesn't die because it's not a suspensive condition. The agreement continues, and the buyer is simply in breach of the agreement, which we'll come to. With regard to a suspensive condition, of course, if the suspensive condition is not fulfilled, well, then the agreement lapses. And the correct terminology here is not that the agreement, when the buyer doesn't get the bond, the agreement is not cancelled, because there's no agreement to cancel in the first place. The agreement lapses because it never existed in law in the first place. So essentially, the agreement falls away, and the parties are restored to their condition prior to contracting. When I interview paralegals, one of the questions I ask them is, I say, I give you an offer to purchase. There's a suspensive condition. It's subject to the buyer being granted a mortgage bond. You call the buyer, the mortgage bond is not granted within the time period. So, for example, my clause here, the agreement is subject to suspensive condition. The agreement is subject to the suspensive condition that the buyer accept the buyer is granted a mortgage bond of 1 million Rand, or such lesser amount as may be accepted. So I then ask the paralegals, I say to them, well, the bond is not granted. Can you place the buyer in breach? And some of them say yes, and some of them say no. When they say yes, I'm afraid I can't employ them, because the reality is then that you can't place a buyer in breach for not having fulfilled the suspensive condition, because the reality here is that the agreement lapsed. It falls away. So there's no need to place the buyer in breach when they don't get the bond, because the agreement has then fallen away. On this topic, and I don't intend to spend a lot of time on this topic, is I just do want to mention to you that there is something called the doctrine of fictional fulfillment. And essentially what the doctrine says is that when you enter into an agreement subject to suspensive condition, the person in whose favor the condition is drawn must take all reasonable steps to fulfill that condition. And if they then don't take all reasonable steps, then they are in breach. But that's something different from what I said a bit earlier. So in other words, I enter an agreement to subject to a bond. I must take all reasonable steps to fulfill that bond clause. If I don't, I can be deemed in breach. But again, I don't want to go into that into any detail, because that's going to digress from my topic. If it happens to you, you're welcome to give me a call and we'll discuss it. So let's talk about a breach, right? So we've got a suspensive condition. It's not fulfilled, our agreement falls away. Then we have a breach. Now, if this is the most typical way in which we find agreements are cancelled. It's so both the seller and the purchaser both have contractual obligations. So, for example, the buyer must pay the deposit. The buyer must produce the guarantees. The seller must pay, must sign the conveyancing documentation. Pay for the rates clearance figures, that kind of stuff. So where a buyer, I'm going to use the example of a buyer, where the buyer goes into breach, the seller has options, right? And let's use the example of the buyer has the obligation to pay a deposit of 100,000 Rand within 5 days of acceptance of the agreement. The buyer doesn't pay the 100,000 Rand. So there's two options. One, we allow the buyer more, the buyer's in breach after 5 days, we allow the buyer more time. That's what we do. The second option is we can action the breach by placing the buyer in breach. If we're going to place the buyer in breach, we need to act in accordance with the breach clause in the agreement, and we need to write a letter to the buyer. Dear Mr. Buyer, you entered into agreement on this day. The obligation was to pay a deposit of 100,000 within 5 days. You failed to pay the deposit. Therefore, you are in breach. That's the formula. We hereby give you 7 days within which to rectify your breach, failing which we will have the options set out in the agreement and in law. Okay? So the point that I'm making is that not every breach is actioned. If the buyer is late, if he pays within 7 or 8 days, we don't have to place him in breach. He paid within 7 or 8 days. He's cured the breach, and we can now move on. Right? It's done. All is forgiven, and we move on. So a typical breach clause would look something like this. One says, in the event of a breach of the agreement, the aggrieved party can give the defaulting party 10 days written notice to remedy the default. If the default is not remedied, number two, if the aggrieved party is the seller, well, after there's a failure to remedy the default, the seller can, one, cancel the agreement and retain the deposit in the conveyancer's trust account and settle off against damage to have proved to have been suffered, or two, we can enforce the agreement. So the seller has the option to cancel, retain the deposit, two, enforce the agreement. We'll explore those in a moment. Three, if the aggrieved party is the buyer, well, the buyer can do the same thing. The buyer can cancel the agreement and claim damages, or two, enforce the terms of the agreement. So the content of the breach clause, guys, it differs from agreement to agreement. So please don't make assumptions that there's always going to be a 7-day notice. It may not be. It may be a 10-day notice. It may be a 14-day notice. It may be a 5 working day notice. So we always have to look very specifically. We can't operate generically. And we must also look at how is this to be delivered. What I always suggest to people is, unless you're experienced in this kind of stuff, let your conveyancer draft the breach agreement for you, the breach letter for you. It's always better to do that because, if you, and understand this, guys, and here's the danger, right? And this is why even some of the attorneys in my office, they get it wrong. And I must check these letters for them. So you write a letter, you get it wrong, you serve the letter, you cancel the agreement pursuant to that letter, all right? Then you sell to somebody else. Buyer number one comes back and says your letter was faulty. It was incorrect. Therefore, the cancellation was faulty. Now you sold to somebody else, but you've got buyer number one challenging you. So you always want to make sure that it's done absolutely correctly, before you move on, right? So after you've sent out this breach letter, right, we need to understand something, and I think this is important because buyer goes into breach. I write the buyer a letter and I place them in breach, right? My 7 days comes and goes, and I don't get a response. I have choices. By virtue of the 7 days having come and gone, it does not mean that the agreement is cancelled. And this is really important to understand. It does not mean the agreement is cancelled, because if I want to cancel the agreement, I must act on that cancellation, and I must send a notice of cancellation to say, so I say, buyer, you're in breach, you've got 7 days to remedy. 7 days comes and goes. My next letter must be to say, I sent you a letter 7 days ago. You didn't remedy your breach. Therefore, I hereby cancel the agreement. So I action the cancellation. Because I've got 3 choices, right? 1, the 7 days comes and goes, no action. I can give the buyer more time. So I can wait for 10 days. I can wait for 15 days, right? 2, I can cancel the agreement. Or 3, I can write a letter to the buyer to say, I'm going to enforce the agreement. So the letter would say, dear Mr. Buyer, I gave you, you breached the agreement. I gave you 7 days notice to remedy your breach. You didn't remedy your breach. I'm now going to court to enforce the agreement. And, guys, the reality of this going to court to enforce the agreement is that it costs a lot of money. It's just expensive. I've been doing conveyancing for more than 20 years. I've seen it happen 3 or 4 times. Honestly, 3 or 4 times. I'm always wary because I'm always reading the case law, so I can see what does happen. And you're quite right, Stan. It's not worth suing in the vast majority of cases. So if you're going to enforce the agreement, you need to weigh up how much will it cost you to go to court, how strong is your case, and how important is this to you? Because like I said to a client this morning, in litigation, nothing is guaranteed. All right. So the effect of the cancellation of the agreement. So now we placed the buyer in breach. There was no remedy of the breach. We cancel the agreement. So we've written a letter to say the agreement is cancelled. Now we want to claim damages. Okay. And sorry, just an important point. Your written notice of cancellation must be served in the same method as your initial letter of cancellation. And be careful about this, guys, because different agreements provide for the service of the letter in different ways. So some say I can email, some say I must send via registered post, some say I must hand deliver. So it's very important to sort of get that right. Let's turn our attention to the issue of my next slide I covered earlier, which is assistance, which I'm essentially saying it can be tricky. It's not tricky, but it can be tricky. Rather consult an attorney, use your conveyancer to ensure that your breach notice and your cancellation notice are absolutely valid. Once you've cancelled any funds, if there's a deposit, we need to really think about exactly how that's going to be held. So once I cancel an agreement, guys, I've really there's really 2 issues that arise. So if I'm holding no deposit, I must decide, am I going to sue for damages? The vast majority of sellers will not sue for damages, especially on residential transactions. It's just too expensive. Most sellers will close the chapter, walk away, find a new buyer. With regard to estate agents, slightly different because you have damages, and the damages are equal to your commission. And again, you need to decide, is it worth suing or is it not worth suing? Sometimes there's a relationship issue. Sometimes, you might think that it wasn't the buyer's fault. Sometimes the amount of commission is not high enough to justify the cost of going to court and the stress of going to court. And sometimes it's worth it. We had a matter here about a year and a half ago where the commission was 1.2 million rand. We brought an application to court and we were successful. So it's well possible, and we have litigation guys here who will take that kind of matter on a contingency fee basis, which means they take 25% of the fee when they're successful. So those kinds of issues are possible. Generally speaking, though, sellers aren't going to sue. If there's a deposit, okay, it does change the picture slightly because now the buyer can't just disappear. Now I'm holding a deposit and I must deal with the deposit. So I'm going to jump ahead to the next slide and talk about the next slide and this slide together. But essentially, guys, if there's a deposit, you need to make sure your agreement is nice and clear. You need to make sure your agreement says that upon cancellation by virtue of the buyer's default, you are entitled to be paid your commission, and the conveyancers are instructed to make payment of the commission accordingly, right? So the difference between your damages as commission and the seller's damages is your damages are quantifiable. I know what those damages are because I know you're entitled to 5 or 6% plus that of the purchase price. The seller's damages are I can't quantify those damages. Okay, so normally what happens is the way my standard agreement works is when there's a cancellation, I'm authorized to deduct your commission from the deposit and pay it to you because your damages are quantifiable and it's clear in terms of the agreement. For the seller, the money remains in trust. If the seller wants to go out and establish their damages by virtue of a court order, they are welcome to do so. And then the money is in my trust account. It can be paid out once they get a court order. On a more practical level, what I normally do is I pay the agent's commission to the agent if it's my agreement, it's nice and clear. If it's not nice and clear, you know what the reality is the agent will have to go and get a court order. If the agreement doesn't say, as a conveyancer, I must pay that money to you guys, if the agreement doesn't specifically say that, I will hold the money and the agent must go and get a court order before they get their commission. So that's why it's important to have your agreements properly drafted with those clauses. Insofar as the seller is concerned, on a practical level, they don't go and sue. So what we do is we reach a settlement. We go to the buyer and seller and say, listen, let's split the remaining money, or whatever the case might be, we reach a settlement. Guys, just a word, lots of guys have these clauses that say that any deposit will be applied to the seller's damages and funds are forfeited as ro quip in favor of the seller. People don't understand this. Ro quip doesn't mean the seller can take the money. The proper meaning of ro quip is that the money is held in trust and the seller must go and establish their damages first. So people misunderstand and that they use this clause ro quip incorrectly. Please also note, guys, that we have a piece of legislation called the Conventional Penalties Act. And what the Conventional Penalties Act says that if you suffer a loss by virtue of a penalty, you're entitled to go to court and have the penalty reduced. So I'll give you a practical example. I'm a buyer, I enter into agreement, I pay R1 million deposit, okay? I pay a million rand deposit, and I breach the agreement, the seller takes my R1 million. The question there is, I've suffered a penalty, has the seller suffered R1 million damages? If not, I can go to court and ask the court to reduce those damages to such that the seller repays me some of the money on the basis that the seller is only entitled to receive the actual amount of damages. But of course, that means as a buyer, I must go to the court and I must prove those damages. Okay, so I've covered this clause, this slide already, essentially just reiterating it's important to have your clauses correctly drafted so that the commission can be paid to you. Let's look at two more ways in which we can cancel an agreement, because, guys, in my experience and over many years of practicing law and being a conveyancer, the breach clause is the way agreements get cancelled. That's the normal way. Very unusual, and I want to talk about two more ways. One is repudiation. So what is a repudiation in law? A repudiation in law is where by my conduct and my action, I express an unequivocal intention not to be bound by this agreement. So I'll give you a very simple example, all right? We're in an agreement. I'm the seller. You perform beautifully as the buyer. I'm the seller. I decide for whatever reason my life circumstances change. I don't want to sell anymore. So I write you a letter and I say, I am not proceeding with this agreement. I'm going to cancel. Sorry, guys. That's it. I'm canceling. I am, by my action, repudiating my obligations arising from the agreement, and I'm telling you I'm not going to proceed. So I've repudiated my obligations. The test is objective, right? The test is objective, not subjective. So we look at the parties' actions and we say, have you acted in a manner that the reasonable person can draw the conclusion that you don't want to proceed? So maybe a more subtle thing is, I just refuse to take any phone calls. I'm the seller. I refuse to take any phone calls. I don't reply to any emails. I don't come to sign my documents. I do nothing. As a buyer, you actually have a choice here. One, you can place me in breach, which is the route that I recommend you go because it's safer. Or two, you can simply write me a letter and you can say, Dear Marius, you the seller, you enter into an agreement. You don't take phone calls. You don't take emails. You haven't responded in the last 2 months. It's clear from your conduct that you don't intend to proceed with this agreement of sale. Therefore, you have repudiated your obligations arising from the sale agreement. As the buyer, I accept your repudiation, and this agreement is hereby cancelled. Okay. So the innocent party, being the buyer in my example, has a choice to accept or reject the repudiation. If I reject it, I'm going ahead. So I could also write it in and say, Marius, by your conduct as seller, you've repudiated your obligations. I completely reject your repudiation out of hand, and I'm enforcing the agreement, and I go to court to enforce it, right? Guys, the problem with the repudiation is it's quick because I don't want to place you in breach, but we have a breach clause. I always suggest rather place somebody in breach. Give them the time period. You know, sometimes people get a fright when they get a breach clause and they react. It's just a human reaction. So I prefer repudiation can be used. I prefer breach. Okay. The last one that I want to talk to you about, guys, is misrepresentation. And This happens very, very rarely. It hardly ever happens that an agreement is cancelled due to misrepresentation. So this case over here that I refer to you, it's the case of Speckman versus Tatram. All right, what happened there, the basic facts of the case were that the buyer bought a property, and there's a long history to it, which is set out in the case. But essentially, the buyer bought a sectional title unit in a sectional title scheme consisting of 2 units. So he bought unit 1 and somebody else owned unit 2, but it was obviously part commercial, part residential. Unit 1 was commercial, unit 2 was actually individual units, which are comprised 10 individual dwelling units. And during the lead up to the buying, the seller's attorney said to the buyer told them that the seller may not, without first going to the buyer or the other unit owners, subdivide this unit. So unit 2 could be subdivided into 10 individual units and then sold off, right? So once the buyer then bought the property, he then found out, well, actually, the units have actually been subdivided. And the buyer then said, listen, this is a material misrepresentation. It's a deliberate misrepresentation. It's fraudulent, and I want out. And the court said, yes, you can get out. So that's maybe a complicated example, but that's what the case said. Let's just look at it, and then we'll talk more about it. So in misrepresentation, there's 3 kinds of misrepresentation. One, it's fraudulent, right? And this is made when a fraudulent misrepresentation is made when I know the truth, and despite I know the truth, I recklessly I tell you a lie. I misrepresent the true facts, right? 2, it can be made negligently. And negligently is when the mistake or the misrepresentation is made honestly, but I'm careless, right? I was negligent. Or 2, it's made innocently. So in other words, I innocently don't tell you the facts. There's no fraud, there's no negligence. It's an innocent misrepresentation, right? And the whole point here is when a seller makes a misrepresentation to a buyer, and it can be made through the agent, of course, there's a misrepresentation. The buyer is induced to enter into the agreement, right? I'm induced based on your representation. So in this particular case, the buyer was induced to enter an agreement on the basis that he thought that these units downstairs, the unit 2 couldn't be subdivided. So when is it justified to cancel an agreement based on a misrepresentation, right? And what this case tells us is that the emphasis has shifted on the nature of the false element, to the nature and the quality of the consensus, vitiating or vitiating the error caused by the misrepresentation. So to make it simple, whether a misrepresentation justifies a cancellation of an agreement is the threefold inquiry. 1, was there a misrepresentation? 2, who made the representation? And 3, was the other party misled by the representation? Okay, so the next question has been materiality. Whether the party misled, so the last question to consider is whether the party was actually misled, and would a reasonable man have been misled? Okay, so I know this is a complicated issue, and let me give you another example to maybe simplify it, right? Seller, I'm a seller, I'll sell you a property, you're the buyer. I know that there's a problem in my roof, right? I know there's a problem in my roof. I don't tell you though, all right? And you now buy the property, you find out that there's a problem. If the problem's going to cost you, if the property was 5 million rand, and the problem to fix the problem is 10,000 rand, well, then you're entitled to a reduction of the purchase price. You're not entitled to cancel the agreement because there was a misrepresentation, but it wasn't material enough for you to cancel. But let's say the roof's going to cost us 1 million rand to fix. Now it's material. Now, I either fraudulently, negligently, or innocently made a misrepresentation, all right? You've acted on the misrepresentation to enter the agreement because I said to you the roof is good. The roof's good to go. You enter into the agreement. The roof is not too good to go. You find out, and now we found it's going to cost 1 million rand to fix. On that basis, you don't want to place me in breach, right? You don't want to place me in breach because you don't want to say you must rectify the breach because maybe I do go rectify the breach, but now you don't want the property anymore. So what you do is you write me a letter and you say, there was a material misrepresentation. I was induced to enter into the agreement, and I'm hereby cancel the agreement on that basis. So that's good in law. But I can tell you guys that it's so arguable, it's so arguable. I mean, I'm not going to get a quote that says it's going to cost me 300,000 Rand to fix. Now, is 300,000 Rand to fix the roof material in regard to the purchase price? It's arguable. And the one thing that I've learned about litigation, it's risky, guys. It's risky. So, guys, that's really it. And I so you got breach, you got suspensive conditions, ordinary conditions, you got breach clauses, you got repudiation, you got misrepresentation. And that's kind of a very broad spectrum overview of the law around what can happen. As I say, guys, what we rather want to do is we rather want to place someone in breach. And, my experience has taught me that it's better to place them in breach sooner rather than later. I know it feels uncomfortable because it feels a bit nasty, but it's better to place someone in breach. You tend to get a better result from people when we move forward. All right, guys, that is it from my side. I see Stefan's put a little quote there. Our days can be brilliant teachers. Our weeks can be intelligent lessons by Robin Sharma. Guys, I hope that's been helpful to you. Yeah,
Thanks, Marius. I think you just hit the nail on the head. You actually just don't want to go into that case of suing a client because it's just too costly. So rather make sure your contract is airtight and that you've discussed all the terms and conditions with the parties and they're very clear on their performance.
Yeah, I spoke to an attorney this morning on a matter I'm dealing with, and we're trying to settle out a matter that might go litigious. And he said to me, Marius, talk to your clients because no one's going to win if he doesn't settle. And I want to say to him, yeah, who's going to win if he doesn't settle? You're going to win. And I always tell people, the only thing that litigation does is makes lawyers rich.
Yeah.